computer. Good morning, everyone, and welcome to this particular session where we are focusing on intellectual property. So my name is Victor Otieno. I'm the Managing Director of Viffa Consult, which is a startup and SME research and consultancy, where we use research to inform policy as well as inform ESO programming around startups and SMEs. So we are focusing on intellectual property as a series. Yesterday, we had the privilege of hosting KEFIS, where we were able to discuss agri-based, entrepreneurship and the IP that are within that particular purview, which was quite interesting. I mean, I didn't know that we had around 1959 applications within KEFIS, with 71% being foreign entities. And of course, the opportunity there was that we need to be able to grow the 29% local IP so that we are able to get more value within the agri value chain. So there are opportunities for entrepreneurs, there are opportunities for collaboration, and I think that was a fantastic conversation that we had. So today, again, we are proceeding with the same conversation, focusing now on copyright. As an IP, and we are very much privileged to have with us Ms. Sharon Water, who's a Deputy Director Training and Research at the Kenya Corporate Board. So without wasting too much time, we'll basically just go through a presentation from Sharon. Then maybe at the end we can just have a few questions. Then we can have reflections on a way forward in terms of how do we collaborate to support entrepreneurs. Understand IP within corporate, what programs can we be able to do to ensure that we continue to support them. So without wasting too much time, Karibu Sharon, the floor is probably yours.
Thank you. So Victor, I'm not Miss Sharon, I'm Mrs. Water.
Apologies.
Yeah, as you rightly said, I'm the Deputy Director in charge of Training and Research at Corporate Board. I am also an intellectual property lawyer. And I'm happy to be here with you. So I structured my presentations to begin with the general what IP is, and then I will narrow down on copyright. Then I'll probably say something about SMEs and startups and IP, yeah? Yeah, so I started at the basic, what is property? And if you look at the word property as defined in the dictionary, it just means a thing or something that belongs to someone or possessions collectively. Then in law, it means anything owned by a person or an entity. So in law, we know that there's a human person, but there's also a legal person. Yes, property that belongs to your person, but you can also have property that belongs to a community or a state. That is how the law looks at it. Actually, if you look at the Constitution, it defines property. Part C talks about intellectual property. So also in our current Constitution, intellectual property is considered to be property, and it is protected by the Constitution. We have several instruments that protect intellectual property. Right now, Constitution of Kenya 2020 in several articles, 40, 69, Article 11, they talk about securing intellectual property. But also, if you look at the Universal Declaration of Human Rights, it also talks about protection of IP as a human right, yeah? So that is how seriously it has been taken in the recent past in the legal instruments. So IP or intellectual property basically is the kind of property that results from the fruits of your mental labor. It deals with rules of securing and enforcing your legal rights to one, inventions, and secondly, artistic works. So intellectual property is divided into two. You have what we call industrial property. This includes patents, trademarks, geographical indications, industrial designs, trade secrets, and others. Then you have copyright. Copyright is what protects literary, musical, and artistic. And now also there's software and computer programs that is protected under copyright. And then, of course, you have plant breeders' rights. Victor, you said you had this conversation with the Kefis yesterday.
Yeah.
So I will not need to go into that. I'm sure you were told what the plant breeders' rights are and why they are protected and how.
Yes.
So I'll skip that bit. Are you planning to have a session with Kipi also?
Yes, we had sent them the invitation to the MD, Mr. John, as well as the Anti-Counterfeit Authority. So hopefully, in the next subsequent couple of weeks, we'll be able to bring them on board.
Okay, so I'll just touch up on the rights they protect, and then I'm sure when you have a conversation with them, they will do details. Yeah.
Okay.
So under industrial property, you have protection for patents or patents, depending, Victor, on which school you went to, whether it is group of schools or
Polling station.
Polling stations. So for some of us who went to the group of schools,
Yeah.
you see patents. So basically, a patent is an exclusive right that is granted for an invention, which is either a product or a process. And generally, it's supposed to provide a new way of doing something, or it offers a technical solution to a problem. So, for example, there's a time transport was a problem. I guess people walked, and then at some point they used animals. At some point they used horse and cart. And so to make that easier, someone came up with a car. So that was a solution to a transport problem. And it was a new way of doing something. So the person who invented the first car gets the patent. So you can actually do an improvement of an invention that's already there. So, for example, you had a manual car, then someone came with an automatic car. So the automatic is an improvement to the manual. So the person with the automatic car gets a patent also. The person with the manual car gets a patent. Then it got to a point, someone invented an aeroplane, which is faster. Someone invented a ship. I mean, it was a solution, a technical solution to a problem that's existing, which is transportation. It could also be a product, a process of making soap, a process of making soda, a process of making something. So their product is given a patent, but also that process can also be protected by a patent. So to get the technical information about the invention must be disclosed to the public in a patent application. Yeah, when you're applying, you have to disclose the technical information. How do I make this? What is the process, or how that technical thing is made? The patent also must meet the 3 requirements. 1, novelty. Novelty just means it is new. It has never been done anywhere. So you see, like now, Victor, you can't come and tell us you've invented a car, because that's not new. It is already there, yeah? It also needs to be useful. It can be used. It's actually something you have invented that can be used. So you cannot say you have invented something, yet it's not useful anywhere. It cannot be used, yeah? And then it also needs to be non-obvious. So the test they use here is it obvious to what the law calls a reasonable man or a person within that field? Is it obvious to them? If it is obvious to them, then that's a problem, but it should be non-obvious. It's not obvious. So not obvious means there's actually some invention that has gone into creating this thing, yeah? A patent generally will last for 20 years from the date of filing. After 20 years, that's it, it expires. It's in the public domain, and the public can use it as they want. So the whole idea is we've given you 20 years, mint as much money as you can from this patent, recoup the costs that you put in creating this thing. After 20 years, we are done. So this is an example of the front page of a patent application for an invention by someone who was called Mr. Dean Kamen. And subsequently, this was commercialized as a Segway human transporter. That is the picture of the transporter itself. But when you look at the drawing, the person had to draw how it's supposed to be used, yeah? So they were demonstrating that on a patent application in the US. And you can see this is 2014, yeah? Then, so that is a patent. Then a trademark, this is a sign that's capable of distinguishing goods and services of one business from those of another. So basically, a trademark like Coca-Cola, when you see Coca-Cola, you're able to tell, oh, this is for Coca-Cola company, and you're also expecting a certain quality of soda from it, yeah? So I can't just make a black drink, Victor, and call it Coca-Cola. Because when you drink it, definitely you'll be like, this is not the Coca-Cola I know. So you're distinguishing that company from your company, and also it speaks to the quality. A trademark usually is given 10 years, but it's renewable. So you can keep your trademark for life, actually. Just make sure every 10 years you renew your trademark. It could be a word, it could be a combination of words, it could be letters, it could be numbers. All this may constitute a trademark. It could be a drawing, could be a symbol, could be three-dimensional figures like shapes, packaging of goods, color, shades, all that could make a trademark. On that note, Victor, maybe when you speak to Kipi, you will find out. But I heard that actually had trademarked the word Allah as a trademark.
There's also one going around of Bazoo.
or Bazoo. Yeah. So maybe Kipi will tell you more about that. And the process, of course, of applying for a trademark. So these are some of the trademarks that we have that are very common. Coca-Cola is a very common trademark, Nike, Google, Ford. So if I was going to register a trademark, and maybe I call mine Mike instead of Nike, and then I put that sign for correct, yeah, like a tick, there'd be a problem. Because you're not supposed to create a trademark that is similar to another existing trademark that can cause confusion in the market to the other person's customers, yeah? I remember in Kenya, there is a matatu that goes to Western called Molo Line, yeah? So there's a time someone came and another matatu guy came with Molo Line. And when you go to the stage and you're like, Molo Line, I don't know, they all just look the same, yeah. People liked Molo Line because they were driven well, they were comfortable, and they were fast. You didn't have to stay on the road for long. Then Molo Line comes and, probably they are not the same quality, probably they're not being driven in the same way. You can see that's a problem. And I think that was a live matter in court, and the person who had the first trademark, Molo Line, won, yeah? So you're not supposed to create a trademark that you can use to confuse customers of somebody, yeah? Then we have also industrial designs. This constitutes the ornamental aspect of an article. So it protects the visual appearance of a product and not necessarily the function. This one sometimes is used for clothes, for jewelry and furniture. It may consist on three-dimensional features, like a shape of an article, or two-dimensional features such as patterns, lines, or color. The shape of the Coca-Cola bottle is actually protected under industrial designs, that unique shape. I've heard sometimes people say that ladies are shaped like that. I do not know. But this unique shape, Victor, is protected as an industrial design.
Yeah.
So if you're coming up with your own and you want to put a bottle, you're not allowed to do this, as long as it's protected, to use this shape. As I said earlier, this protects the ornamental aspect of an article as in its visual appearance, as opposed to the function. Sometimes you will see some of them, like,
Yeah.
if you look at my screen, I have some dresses there that are designs that have been protected before, but they don't look practical. Yeah? Like, where are you going wearing such a dress? It doesn't look practical. Yeah. But what is protected here is the way it looks, more than the function of that dress. Yeah. This is that kettle. Of course, being me and where I come from, I had to use a kettle for chai,
Yeah.
So that kettle design was also has been protected as an industrial design. You can see it, the design is nice. So it doesn't matter whether it's functional or not, but it's about the design when it comes to industrial designs here. And then we have something else called geographical indications. This is still under industrial property, one of the branches of intellectual property. So this is a sign used on products that have a specific geographical origin. And then they possess qualities or a reputation that are due to that origin. So there's a clear link between the product and its original place of production. Typically, you'll find this is used on agricultural products, foodstuffs, wines, spirits, handicrafts, industry. We have in EU, you will have assigned for cheese. We have had for wine, like the wines from South Africa, they may have a certain geographical indication. So you know this one is from South Africa. The wines from Italy, and it's not just Italy as a whole, it is a certain region. You would have a geographical indication showing that it's from this, and the grapes that are used to make the wine are grown in this region. So you're also expecting a certain quality of it. In Kenya, for example, we could decide we have a geographical indication for maybe tea from Kericho, as opposed to the one grown in Nyeri or in Murang'a, so that you know this tea is actually from this region and you're expecting a certain quality out of it. Yeah, I think the soapstones of KC could also qualify to have a geographical indication, whereby you know these products are made with stone from this particular place. Yeah. Then there's also one called trade secrets. And as the name suggests, this is an IP right on confidential information, which may be sold or licensed, yeah? So mostly you'll protect manufacturing processes, pharmaceutical test data, designs and drawings of computer programs, commercial information, even lists of suppliers, clients, advertising strategies. You can protect this under a trade secret. Also, financial information, formulas, recipes, source codes. These are best protected under trade secrets. So in general, to qualify for a trade secret, the information must be commercially valuable because it's kept secret. It should be known only to a limited group of persons. Like we've always had the formula for creating, processing the Coca-Cola soda is a secret, and that just very few people know it, and they don't know each other, and they don't know what the other knows. I don't know. If this is a secret, then you're able to keep a trade secret. But the moment the secret is out, then there's a problem, yeah? You also have to show that you have taken reasonable steps to hold the information secret. So usually you'll have your employees sign confidential agreements and things like that, yeah? Then, of course, another arm of IP is copyright. As I said earlier, this one protects literary works, artistic works, musical works. And then now we have computer programs and software. Then you also have architectural designs that are protected under copyright. So I'll exit this one so I can pick my presentation on copyright. Up to there, Victor.
Yeah.
Would you have a question now that you're the one who's here?
Yeah, so I mean, so a couple of questions that we had shared the poster out, and we were able to receive a couple of questions from different stakeholders. Number one is there a program? Because what we also realize is there are a lot of IP that have been registered with different IP bodies, but some of them have expired. Is there an opportunity for entrepreneurs to be able to access this, either whether it's copyrights or whatever, for them to be able to create a business around the same, especially for IP that is open but has not been exploited? So is there a program around the same? That I think largely would be the first question before you do your second presentation.
Okay, so now I've just covered IP in general, and we have seen that patents expire after 20 years. So after 20 years, a patent is expired, it is expired. So that means that anybody can use it without getting a problem. It's just that after 20 years, I don't know how much valuable it still would be for you when you're using it.
You realize that because let's say, for example, a patent, ultimately, a solution as an entrepreneur, and in Kenya specifically, we have a very big challenge of our sector focus for a lot of our entrepreneurs is wholesale retail, meaning that a lot of entrepreneurs just buy to sell because that's it's very enter into such business. It has no capital. And because we don't have market intelligence and knowledge to build products, sometimes is you want to see, something that has worked and try to build a business around even if it's not, we're not going global, but at least it's different. You are able to have some differentiating factor. So just being able to exploit either IP in one way or another can be able to help and support and have diversity within the economy. So I asked this question because at some point I remember someone had indicated that there is a lot of idle IP that is sitting at the regulators. That maybe it's free to access, but we have no, either we don't have information about it, we don't know where to get, and there's no program that can be able to help me build this IP to a business, even if it's not like we want to be able to go global.
Okay, I'll address that a bit more in detail when I do the last presentation on SMEs, entrepreneurs, and IP.
Okay.
But what I can say for now, an area like patents, that's a rich area because you see, a patent can be given on an improvement of an already existing thing. So once, for example, you know that there was this machinery, you can look around it and see how can I improve it, or there's this product or this process, how can I improve it a bit, then you get a new patent for it. So I see an opportunity in terms of patents. Usually most people want to maintain their trademark. So if I have trademarked, for example, Coca-Cola or Google, I will want to continue using it. So that means ninachungana nayo, 10 years I renew, 10 years I renew. So unless you're just timing me to lapse, if I haven't renewed and the 10 years have lapsed and you run and register it, which really doesn't make sense, so with trademarks, it's renewable. A trade secret is good as long as it's a secret, and so it really is just kept a secret. For something like a geographical indication, maybe if we have a geographical indication for a product from a certain place, it's to want to go and invest in that place and still also do that product, I guess. So there's lots of opportunity. One of the things I would say probably is also, if you are in a certain business or an entrepreneur in a certain area, it would be nice to do your research in terms of what IP exists around that area and search the database and see what is there, what is lying dormant, what can we build on, what can we improve on. Things like, especially biotech patents, like the patents that are given for biotechnology and medicines and things like that. That's the area that you see people build businesses around a lot. Because every other time there's an improvement of a dawa in the market, it's not from the air, it's usually from an existing product already, an existing patent already. So let me move on to copyright. So copyright, on the other hand, we are talking about a right that is used to protect. Oh dear, what did I do? Can you see my screen still?
Yes, we can. I can. Yeah, it's fine.
Okay. I said copyright describes rights you're given for literary works. By literary works, I mean like books, novels, poems, newspaper articles, what is written basically. So now we all agree that we have moved from the physical book into online, So whatever you are posting even online is protected on copyright. Even if I write a poem online, the other day I was talking to someone and they're telling me, I've been posting my articles online and they're being misused and people are taking and publishing. I told her, you can protect them. You can definitely protect even what you've posted online, And then artistic works, we're talking about things like paintings, drawings, photographs, illustrations. Initially, we talked about industrial designs. You could also protect industrial designs, a design under an artistic work as a copyright, yeah? Then
Thank you. I don't know if you're on mute.
can you hear me?
Yeah, now I can hear you. I think you had gone on mute. Again, I think your audio is out. I think it's going on and off.
Victor, can you hear me now?
Yeah, I can hear you.
Okay. Am I still sharing my PowerPoint?
Yeah, I can see it, but it's on, you just need to put it in presentation mode.
Okay. Oh dear.
No, you can go to slideshow, then either you start from the beginning or.
I'm not sure how to get there.
If you can see the slide from your end, is you either you go on the top slideshow, then you it would give you the option of either start from the current slide or start from the beginning.
Okay, let me stop sharing first. Then I share my screen again. There. Share.
Okay.
So you can see it.
Yeah, I can see it.
Is it in the presentation mode?
No, it's still as. But
No?
yeah, now that's, yeah, so I can see it.
Okay. Yeah, so I was saying, Victor, with musical works, I was explaining how copyright covers that. So, for example, Victor, which song do you like?
I listen to gospel music.
Uh-huh.
For example, Guardian Angel. Guardian Angel is a person that I listen to.
Oh, nice. Yeah, so if you hear a song by Guardian, I think Guardian has some hymns. He does some hymns in very interesting style, yeah?
Yeah.
So that the words of the song, like one of the hymns he has done, E Bwana Uniinue, the words are protected under copyright as a literary work. Then the tune would be protected. Na, 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 na. The tune is also protected. Then, if it is a sound recording, like he's just recorded the song in sound, it's protected under a musical composition and a sound recording. But once he has done the video is a different work. It's also recorded. It's also protected as a video, as an audio-visual work. Yeah. Now, with works like musical works, you have an author, composer, the person who writes the words of the song, the person who puts the tune. Then you have the performer, the person who you hear their voice come through when you listen to the song. And then you have a producer somewhere who does the magic to do the production, the background, the instruments and everything. So the copyright protects 4 people in that musical work, yeah? Then the other work that copyright protects is computer programs and software. The apps that you have on your phone nowadays, we rarely go to the bank. You just download the app, do your transactions there. So those apps, the creators of the apps get a copyright for that. The software we use, all that, people get copyrights. Also, architectural designs are protected under copyright. Now, copyright would protect expressions of ideas as opposed to ideas and concepts. So, for example, I can say I have an idea of going to do a photo shoot on the, what is that road called? The one from the airport, the up road.
Which airport?
The road, the one from JKIA, the road that was built that connects to Westlands.
Expressway.
Expressway, yeah. So I can say I'm going to do a photo shoot on the expressway, maybe on a Sunday. That's the idea. Or go up there and take photos of the city of Nairobi. That's the idea. So copyright will not protect that idea and say nobody else will ever go up there and take photos. Copyright will protect your photos that you have taken while you're up there. Okay? So copyright protects how you express an idea as opposed to protecting an idea. And that's the reason I'm emphasizing that is because a lot of people will tell you, I have this idea, I need to protect before someone else thinks about it. Excuse me.
It's absurd.
With copyright, it's absurd. We are not protecting ideas because you're not the only genius in the whole world that you'll only think about this and nobody else. Copyright will only protect how you have expressed your idea. So copyright gives you two kinds of rights. Excuse me, let me take some water.
Yeah, no, that's okay.
Excuse me.
Sorry.
So then copyright will give you two types of rights. There's a right called economic rights and moral rights. Yeah? Economic rights basically, so the idea of copyright is this. Copyright says if you're the creator of this song, then you have the right to decide who uses it, how they use it, and where. And then you also have a right to receive money whenever that thing makes money, yeah? And you also have a right to be known as the creator of it. So the economic rights copyright gives you a right to, there's a right called reproduction. So Victor, if you've written a book and I want to make many copies of that book, that's reproduction, I need to ask for your permission or pay. If you have done a song, I want to reproduce that song, I need to ask for your permission or pay. There's another right called adaptation and translation. Adaptation is like how you convert a book into a movie. I need to ask the owner of the book for that permission to translate it into a movie, create a derivative work out of it. Translation, if you have written your book in Kiswahili and I want to translate it into English or into French, I need to ask for your permission. Distribution, if I want to distribute your book, go sell. Distribution could be by way of selling, lending, posting online, that is part of distribution. I need to ask for your permission, yeah? Broadcast, if you're a musician like Victor, you decide I like Guardian Angel, you pick all the songs and take them to a radio station and say, you play Guardian Angel I like. That is part of broadcast. You need to pay or ask for his permission. Communication to the public, even that broadcast is communication to the public, yeah?
Yeah.
Public performance. If I call a crusade, Victor, incidentally, Victor, I also listen to gospel like you, but I'm also a singer. So if I decide I'm doing, but I don't write music. So if I decide I'm doing a concert or a crusade, and then while I'm there, I'm singing Kigame songs, Gloria Muliro, Eunice Jerry, I need to pay for a public performance license or ask for permission from all those people, yeah? That is like public performance. And when we're talking about public performance is defined as being in a public space with people who are outside your normal family and friends, yeah? So Victor, I have a large family. I have over 70 cousins, first cousins on my mother's side.
Wow.
So if I was at a function with my 70 cousins, that is not public performance because these are within my circle of family. But if I was with 20 people from my office that are outside my circle of family and friends, then that would be considered to be public performance, yeah?
Yeah.
And then the other right copyright gives you is called the moral right. Basically, this is the right to attribution. If Victor has sung this song, it must be heard and known that it is Victor's. If Victor created this thing, if Victor shot this movie, did this, it must be known it is Victor. So that's attribution. There's another writer. This one is used a lot for publishers and authors, the right to anonymity and pseudonymity. We have people who publish things anonymously, even articles in the newspaper. Sometimes you'll read an article and see it is written by anonymous, probably because of the sensitive nature of that article. You don't want to be known, or use a pseudonym. Yeah. I don't know if you've watched the movie Out of Africa. It's about Karen Blixen, and the time when she lived in Denmark, she was from Denmark. She was not allowed to publish. Women were not allowed to publish books. Yeah. So she used to use a man's name to publish her books. And only after that was lifted is when people began knowing, oh my God, this book I love so much was written by a woman. But all along, she used to use a male name. So that is using a pseudonym. Copyright law allows you to do that. Yeah. The book, like the one Miguna wrote, Peeling Back the Mask, if he didn't want to be known as the author, he had a right to use a pseudonym or to publish anonymously. So you may find such a book with sensitive information and whatever can be published anonymously. So you only see it is by anonymous, you don't know who wrote it. Yeah. And then the other moral rights, the last one is the right to integrity. This is the right to objecting to your work being used in a manner you don't like. For example, if I'm a gospel artist and my song is being played in nightclubs or it's being put in pornographic movies, I have a right to integrity, so I can object to that. Yeah. I remember there's a time when this song had hit, Kunadawa. I used to hear that it used to be sung in nightclubs.
Yeah.
And the Walevi would be very happy singing it. The owner of the song was happy. She was saying it has reached there. It can minister to people. Yeah, but somebody else would want to object to that if they have a right to, actually. Yeah. So requirements for protection of copyright, one of it is originality. Originality just means that you independently created that thing. Like you sat down and created it, yeah? It was not copied from somebody else. And then fixation, it needs to be in a tangible medium of expression, e.g. a book that's tangible or even online, a photograph, a drawing, a song on a CD or online. So it needs to have moved, Victor, from your head into a tangible form. And this would be nice for people to get, because a lot of times you get people who come to the office and say, I have this idea, I want to protect it before I remove it so that it is not stolen. We can't protect an idea in your head. Copyright does not protect an idea in your head. It needs to be fixed in a tangible form where it can be accessed by other people, yeah? Then you get protection. Copyright, however, is automatic in terms of once you have created that thing and you're fixed in a medium where people can access, then automatically copyright protection covers it and you have a right to complain, yeah? In Kenya, protection lasts for the life of the author plus 50 years. So Victor, like Guardian Angel, his songs, they are protected by copyright as long as he lives. Then let's assume he dies when he's 100. 50 years after his death, it's after the end of the year in which he died. So let's say he dies in 1930s, in 2030, 2040, whatever. If he died in February, you count from December. 50 years after that, copyright still subsists in his songs. After the 50 years, then copyright lapses and it comes into what we call the public domain. That means then, as you were talking about, people can now use it without permission and without paying. So that's another area in terms of copyright where entrepreneurs can tap into. You check, has copyright lapsed in this thing? If you look at hymns, like now, a lot of people are singing hymns, and the reason they can sing is because most of them, the copyright lapsed. In UK, copyright lapses 70 years after the death of the author, even in the US. So already, if you look at a hymn book, you'll see those hymns were written in 18 something, meaning the people lived, died, 70 years lapsed, and now copyright is in the public domain. So you can sing your hymn, you can do whatever you want with it. Same tune, same words, there's no problem because there's no copyright protecting it, yeah? The law, however, there are instances which the law allows you to use copyright without permission. So the idea of copyright is this. Copyright is saying, if Victor created this song, wrote this book, has this software, painted this painting or took this photograph, he owns the copyright and he controls how it's used. But there are instances where the law can allow you to use copyright without permission or without paying for it. And this is called exceptions and limitations of copyright. It is found in the Copyright Act in the second schedule. There are times educational institutions are allowed to use copyright. Broadcasting, you're allowed to use copyright in certain instances. For libraries and archives, like if you find books that are out of print or orphaned works, they're allowed to copy and preserve them for preservation purposes. There's something else called for fair dealing. You're allowed to use copyright protected material for scientific research. For private use, Victor, I mean, you bought the CD, you went with it to your home and you're listening to it in your home or in your car. That is private use, you're allowed. If you're doing criticism and review, if you go on YouTube, sometimes you see people whose work is just to criticize movies or review movies. Oh, this movie has come out, then they play the movie, then they say, oh, this was really silly, they shouldn't have done this, or this was really nice. Just criticizing and reviewing, that is allowed. For news reporting, I'm sure sometimes when you've watched news, you will see a video and they'll put their amateur video, yeah? Probably they arrived on the scene and somebody had taken a video on their phone and they borrowed the video to use or took it. That is allowed, eh? For reading or reciting in public, like a poem, yeah, you're allowed to use copyright. There's something also called for parody, pastiche, caricature. You have a right to use copyright, but you need to acknowledge the person. For judicial proceedings, if I'm in court doing a matter, I'm allowed to use copyright. Parody basically is an imitation of a style of a particular artist or genre with deliberate exaggeration for comic effect. Parody would be like the videos Eric Omondi does with people's songs. Sometimes, I think I saw one he did with Rose Muhando's song, and the video was titled How to Be Rose Muhando. And if you hear the song in the background, it's actually Rose Muhando singing. But if you look at the video, it's Eric Omondi dressed up like Rose Muhando and doing the gestures. It's really funny. So that's a parody. You're allowed to do that, yeah, with copyright protected material. But otherwise, you wouldn't be allowed to take somebody's song and do it in that way because of copyright. Caricature, this is a drawing or a written or spoken description that makes part of someone's appearance or character more noticeable. If you look at my screen, there are pictures I've put there of Obama and Mr. Bean that are a bit exaggerated, yeah? Like, I mean, Obama's ears are not usually like this, but there's funny pictures around it. That means someone took that photo, exaggerated it a bit, or that drawing. That is also allowed under the law if you're doing it for caricature. Those are part of the exceptions and limitations. Yeah, so that's it about copyright. Maybe you can ask another question as I get the last presentation on SMEs and IP.
Okay, yeah, so I mean, so that's a fantastic presentation. I think especially around exceptions on copyright, I think it's information that I think a lot of us within the space maybe are not aware of. And I think it's very important that we're able to explain that. I think for me, where the first question I would ask is around computer programs and software, where we have a lot of startups. Maybe it might fall on the presentation that you are setting up. Would be, do you have any programs around the same? Because what you say that, you know, Kekobo would not protect an idea, but an expression of the idea. So we have a lot of software engineers in Kenya. We have a lot of startups who are doing a lot of stuff, you know, in terms of innovation. So is there a program? Because I always see, or what I see in the ecosystem is there's a gap between you as a regulator with entrepreneurs who assumed that, you know, you are out to get them. So there's a perception of government that maybe entrepreneurs have that they would not want to interact as such. So for me, the question is, at Kikobo, do you have a program that can, either capacity building program or any other program that can be able to support SMEs as well as startups, for them to be able to understand what exactly is copyright? Because I think we make assumptions that a lot of us know, but even some of us who've gone to school still, we think we know, but we don't. So is there a program around the same? If yes, how can someone join? If not, then how can we be able to set up such?
Okay, I don't know what you mean by program, but we have a training and research department, which is the one I head. And what we do capacity building for anybody and everybody who will request or who will get in touch with us, or who we come across. Yeah, we have had a training in conjunction with the WIPO, World Intellectual Property Organization, with software engineers and apps, the people that come up with apps and all that. It was a little disappointed. It wasn't, in terms of attendance, it wasn't very well attended as we thought it would be. And so I would encourage anybody in that space to get in touch with us if they want. If people can put themselves together and request for a training, that's the easiest thing to do. We come, we train you in as much as we can. For software and computer programs, generally what is protected for you is the source code. But you need to be the one who came up with that source code. So you're not just picking someone else's source code and saying, I've come up with 1, 2, 3. You're actually creating an app or a software. And so that source code you can come and protect. Part of the protection is registration. So we have been registering a lot of software. Right now, actually, registration is free. Initially, it has been around 500 bob, but right now it's free. Yeah, and it's online. Yeah, I'll give you the
I didn't know
the
that.
site.
I didn't know that. You can share. Maybe you can put the link on chat. It's part
On
of
the chat, yeah. Yes, let me put the link on the chat. When you go to NRR, that is National Rights Registry.copyright.go.ke.
NRR.
That I've put it on the chat.
Okay.
.copyright.go.ke. When you enter that site, you are able to create an account. If you're an individual, you create an individual account. If you're a corporate, I mean you're a company, you create a company account. You will need a phone number that is registered to you by Safaricom. You need an ID number. You need a KRA PIN to create the account. When you're creating the account,
this specifically
pardon?
is for software.
No. It's for anything. You can register your music there. But see, when you come there to do an application for registration, you will pick software if it's a software that you're registering. If it is a song, you will pick a sound recording or an audiovisual work if it's a video.
So all is free for all the copyright that you apply on that link is free.
For now, it is free. We are trying to migrate to the government system for payments. So the mechanism is still in progress. So that's why it's free for now.
Okay.
Yeah, for now it's free. Maybe I'll do, once I'm done with this, Victor, I may show you practically the registration, if it will allow me to share them.
Yeah, sure.
Yeah, okay. Yeah, so I put together top 10 IP mistakes that SMEs and entrepreneurs make, so that we can just, think about it critically and guard up against this. The first one is public disclosure of idea. So you have an idea, you're disclosing your innovative ideas, particularly with inventions, before filing for your proper IP protection. This may prevent patent or design protection, and it brings the innovation into the public domain, even, before you protect it. So, of course, if you're telling people already that I have this idea, and this is how I made it, this is how I've done, of course, people will run with it before you even reach there. But in terms of copyright, I have seen...
Just a quick question around the same. is a lot of people
Yeah.
are doing, let's say, for example, software development, have to validate because you're not sure if it's going to work until maybe you test it out with maybe a sample public, whatever, selected public.
Uh-huh.
That
Uh-huh.
public disclosure, because I can't patent something that I'm not sure if it's going to work until maybe I test and validate in the market, then I can say, okay, it works. Does that mean public disclosure?
Public disclosure would be you have shown us your source code if it is a linear software.
Okay.
So if it is a software and you have given us the source code, how you created it, that is public disclosure.
Okay.
But if it's just testing it, like, okay, in GitHub, do 1, 2, 3, let me see how it works. No, that's not public disclosure because we don't know the source code behind it. So we can't reproduce it or we can't copy it.
Got it.
Yeah. And again, remember when you're talking about an entrepreneur, you're talking about competition, you see. So if you're creating software and apps and your competition knows your source code, then really you're done, yeah? Yeah. So public disclosures of ideas, we need to gather against this. I have seen this with copyright in terms of like especially around TV, script writers and TV, yeah? You will find someone has maybe done like a script or they are doing like a program and they run to broadcasters because they want to pitch, maybe sell it to the broadcaster. So when they go to pitch this, they give everything and the person says, I'll review and see. Then they tell you, no, we can't work with you. But the next time you see it on TV, you see it's like the similar thing. They have just changed 1, 2, 3. And then you're beginning to say, I'm the one who gave them the idea. It's going to be really hard to prove that, yeah? In the absence of signing an undisclosure agreement with you, it's very hard.
But how can I sign an NDA yet I'm trying to pitch for work with you? I mean, the power balance is not balancing.
That's the problem. But legally, you should be able to sign an NDA with whoever you're trying to pitch your work to. The only problem is that most of us are small startups and, you want the work. And so you're afraid even of bringing NDA in question.
Because I don't have time. Even getting the appointment is hard enough. You're coming and I'm looking for an appointment, but sign here an NDA before I mean, how practical? How practical?
What I have been telling young entrepreneurs to do is come and register your IP first. Like copyright is pretty easy and fast. It takes a very short time. It's easy to do. So once I have it registered, if someone stole it, then it would be easy to prove I'm the owner of it.
But imagine I'm writing a script. I pay 500 shillings. I'm not even sure it's going to be a hit.
Yes.
Why it's almost like a sunk cost. So let me just protect it with the hope that so you're saying it's 500 shillings. I don't know.
No, like if it's in a script, it was 100, but right now it is free. Okay. Now, for me, when I always tell people, don't wait for your idea to hit to feel like it is worth protecting. Your creativity, whether it is a hit or not, is still worth protecting because you do not know whether it will be a hit or not. So once you have done your script, register it for copyright, protect it first. Then start pitching it. It may be a hit, it may not be, which is still okay. Even songs, people sing so many songs. Some are hits, some are not. So if you decide, I'm waiting to see whether this thing is a hit for me to register it, then the moment it is a hit and you've not registered it and it's being infringed upon, then you'll already have a problem. Yeah. So I usually say, even if it's not a hit, just register it, just protect it, protect yourself, and then go around trying to make it a hit. It may actually succeed, it may not. So SMEs, entrepreneurs need to guard against public disclosure of ideas before doing IP protection, yeah? The second mistake that they make, my thing is not moving. Is it moving on your side?
No, it's not. It's still on public disclosure.
Okay.
Maybe it's the PPT is a bit tired.
Maybe it's a bit tired. Let's share again and see. Okay. Can you see it?
Yeah.
Is it moving on your side? No?
Still as a
Resume slideshow. Let's see. Yeah, it's moved, yeah?
yeah, I can see it's okay.
Okay, so number 2, sorry. Not,
Conducting.
gosh.
I
Can you see it?
Yeah, I can see not conducting patent.
What can you see on your screen?
Not conducting patent trademark search.
Oh, okay. Yeah. So before building a business model around an innovative activity, whether it's an invention or a product or a creative design, it's advisable to do a detailed search to determine if there are any existing third-party rights that will hinder you from securing your IP protection. Yeah, so you need to know, are there other people that are already involved in this thing? Are there other people who have rights to it? A lot of people don't do that. You rely on your knowledge and the knowledge of the market and assume that simply because you don't know about a competing product, then you'll be able to secure a protection. If there are other third-party rights, they will buy you from securing a protection. So you need to do that search, look at the market. I usually tell people, if I'm in a certain area of business or entrepreneurship, I need to do research around that area. But sometimes I find that a lot of people don't. You have this idea, you run with it, and you don't even do your homework around this kind of things that you're doing. Yeah.
This database is with the Kobo, or which are we talking about the internet in terms of database?
With trademarks, the database is with Kipi. With patents, is with Kipi. With Kekobo also, if you go to that NRR site I told you, you can actually search, do a search. So if I was going to search for maybe Guardian Angel songs in our database, I'll find them, the ones that he has registered, yeah? You'll be able to see what he has done.
So it means that we need to be able to conduct patent, trademark, design searches with the IP
Yes.
in Kenya.
With the IP office, yeah.
IP.
And in fact, Kipi will guide you on this. I think you can even do an international search. You should be able to do.
Yeah.
I know through the World Intellectual Property Organization you can. I don't know if Kipi have access to that. I think they should have.
They had, you know, in my past life, which is last year, I worked at the county government of Nairobi as a chief officer on digital economy and innovation. And I remember having conversations with Kipi, and they were like, they have an arrangement where they can be able to access the WIPO database, and they actually have a that I think with specific institutions, either I think universities, where you can go and query the WIPO database and to see if they are patents. Yeah.
So it's always good if you're in a certain, like now, if I was manufacturing and making drugs, that would be, I mean, I'd make Kipi my friend, yeah? You would really want to know what is out there, what has been done, what patents have expired, what can I build on? Yeah. The third thing is not using IP maps to create research and development projects. There's always a risk of reinventing the wheel. The marketplace is not an accurate indicator of existing or third-party protected technologies. So you have to conduct a patent mapping analysis, which can give you valuable information on technology before investing big amounts of time and money into a project. You want to know what's the technology that is there. Remember, I said something like a patent could be an improvement of something that is already existing. It could even give you more ideas, yeah, in terms of improving whatever is already there. Like now, my grandfather used to use a charcoal iron box, ile ya makaa, and I've not seen that in a long time.
Even us, we used to use them.
I know. And then someone came up with electric, yeah? That was basically just an improvement of what is already existing. We have an iron box, now it's electric. I can't think of what would be better than what we have now. but possibly there's an idea somewhere that could be better. You never know.
Now they're using
I'm
Steam.
told,
There's a
yeah,
Steam.
now they're using Steam, yeah. And then even better, someone told me the other day, a friend of mine, they have small children, they live in the US. And I said, how do you manage to do laundry? That's usually a nightmare. And they said, oh, now we buy clothes with fabric that is non-crease. Yeah, the fabric that is not creasing. Unatupa kwa machine, unafua, unaanika, you wear it as it is. I'm like, wow, okay. These things just keep on. So it's good to know what is there, what can I establish? You get good ideas out of it, yeah? Instead of just wasting money doing something, alafu naambia, no, this one is here. The other fourth one is not establishing clear IP ownership provisions in employment agreements or with third-party providers.
Maybe just
So,
to take you back a bit on the not using IP maps to create R&D. Practically, from an entrepreneur perspective, who do I go to do the patent mapping analysis? Do they come to Viffa to us for us to do for them? Is there a special body, or do you offer support for such analysis?
as well, we have IP experts here, so they can help you if you came here.
In-house.
But I would, yes, in-house. Our legal staff are all IP, have an IP masters within, yeah. But I always tell them it's good to have an IP lawyer help you with some of these things, yeah. By an IP lawyer, I mean Victor, an IP lawyer. What any lawyer who just tells you they know this thing.
Of course,
not every lawyer knows IP.
Legal colleagues are all over. They're all over.
Na hatukatangi kazi yoyote. If you come to me even now with a child matter, sitakata, if I was practicing, nitachukua. Then the first thing I'll do is go to my class group for LLB.
And inquire.
Nani amefanya child matter before? Sidebar. Then nimuulize. Then I go and read, but I'm not an expert in the area. Yeah.
But the question,
so most lawyers you go to, watakuambia tu kuja. They take it, but they really don't know it. But IP lawyers in this town are known.
I agree, but the question
is
the question is, and I think this has always been the issue of IP, is that of course there is a lack of knowledge.
Yes.
The perception that it is expensive, like for example, you're telling me 100 shillings. But then when you say go to an IP lawyer, already that sounds complicated and expensive. There are ways in which, and for me, it's a question of building a system that can allow. You see the way you said it's easier to go online to NRR, apply for this, and I'm able to do it. Is there a way in which maybe, for example, as Kekobo, you can help entrepreneurs with patent mapping analysis?
Well, for us, Kekobo is about copyright. So I wouldn't want to speak for Kipi because I don't know what they're
I'm
able
talking
to
about
do.
Kekobo. I'm talking about Kekobo, and because you cover software, let's say, for example, computer programming and software, it's within your purview.
Kekobo, we cover copyright, not patents, not trademarks. We have the knowledge, but we cover copyright. So if you came here, for example, to seek for legal help in terms of your copyright, we will offer it for free. Kekobo does that for creatives for free. You come here for legal help, you come here is for someone to look through your contracts, we will do that for you. That's a service we have been doing.
Yeah, so this covers patent mapping analysis. Or you're saying patent is not within your purview?
Patent is not within our purview. We have the knowledge as individuals because we've done the IP masters, but patent is within the Kipi purview, and I don't know what Kipi is able to offer. But I'm sure when you have a conversation with them, Kipi is a government office, so they should be able to offer some of these things. Yeah,
but I think the only challenge I see is a lot of these government agencies sometimes are stretched. Kipi offices.
Exactly.
You have an in Kisumu or in Mombasa.
How
do we create a system that allows for them not to make these mistakes? It's one thing to point out a mistake, is another to be able to offer solution to say, okay, you need to be able to do R&D or patent mapping or an IP mapping. Then the question is, go to an IP lawyer. IP lawyers are expensive. Then I'm stuck. Yeah, so I mean,
I think for me, some of these things, I feel, I could be wrong because I've never worked in the county, but I feel some of these things maybe county governments can take them up in terms of helping the creatives and SMEs and entrepreneurs within their counties, I have worked hand in hand with county governments before in terms of training creatives, and it has worked very well. They know the creatives within their jurisdiction. And like the last time I teamed up with Kakamega County, they brought me like over 100 creatives to train. I couldn't have gotten them by myself, you know. I went to Baringo once again to do a training, and they brought almost 200 of them because they're able to know them and invite them and bring them, you know. And if myself, I just landed in Baringo, I wouldn't do that. So part of these things, I feel county governments can take them up in terms of their support for their creatives within their counties, yeah.
Yeah, so I mean, either it could land under counties or business associations.
Or business associations, for sure, yeah.
So I think because we are members of ASEC and Countrywide Innovation Hub, so we are part of a network of within the startup ecosystem. I think that's something that probably we can be able to pick up and have very particular sessions where maybe startups can come and maybe we can just give them a framework, empower them to be able to do such mapping analysis, or even a template. For me is how can we ease the burden? So say, for example, can you be able to give me a template on mapping of IP? So what are generally things that I can do? Nikilemewa, then I can go to an IP lawyer, but at least I've done some groundwork. Sometimes we don't have to go to the IP lawyer as such. Generally, if I see that this area is covered without even going detailed mapping, then I can say, okay, let me move on. But if I find that in the general public, maybe it's not there, and I've queried the database and I'm seeing it's not there, then I can now engage an IP lawyer to confirm. So that
by the way, the World Intellectual Property Organization, the WIPO website, also has a lot of resources on different things, different topics. You can even find something on with this information I'm giving you. You'll even find it on the website for WIPO, yeah. That's another place to go for information. Their website. They also usually have little courses here and there around these things. It's also a good place for most entrepreneurs to check also. It's a resource, it's a good resource.
Okay, got it.
Then the fourth mistake usually is not establishing clear IP ownership provisions in employment agreements of third-party providers. This one now depends on the jurisdiction and the laws in that jurisdiction. For example, in Kenya, according to our law, if you are creating something under a contract of employment or it's a commissioned work, then the copyright will belong to the company or to the person commissioning you. So for example, if you're employed as a photographer by a media house and part of your work is taking photographs, then it means that the photographs you take are the copyright is vested in the media house, yeah. Not all jurisdictions have the same law. So again, it depends. Which jurisdiction are you dealing with? What does it say about that? So you need to establish ownership of IP before you invest and deal with whatever it is you're dealing with, because you want to invest in something that you can be able to recoup and also have ownership if that's what you want, yeah? So that's also a good thing to establish clarity in terms of ownership of IP, yeah? Again, remember I said, this depends on the jurisdiction and the laws that are there.
So one of the challenges that we see in Kenya, especially, is startups are always called, or entrepreneurs are always boot camps, these competitions, where you're, doing a hackathon to solve a certain problem. So if you win, maybe for example, you go to a corporate, I will not mention any corporate, but if you are to go to Viffa as a corporate, we call out startups or even public bodies. They will say, okay, now we are calling out for a competition for logos to do this. Who should initiate that conversation of saying, this copyright would fall either with the person calling the competition and they give you an award and they end up using the solution that you got to maybe for commercial whatever. Do you join or
usually the people calling out will say and this, you will have to give us the rights to this and whatever. Once we give you an award or we pay you or you are the winner and you get this amount, we retain the copyright. Usually they'd say that. I remember there's a time there was a competition. I think it was a story writing competition with Cadbury that had been put out in the paper, and Kekobo issued an advisory to creatives about it, saying that, oh, remember when you do this, when you participate in this, your copyright, blah, blah, blah. And Cadbury actually had to reach out to us. And we helped them even in terms of pricing the winning person, how they're going to price. Because I think initially they wanted to pay something like 5K, I don't know. But they ended up increasing that a bit and paying a little more and just trying to understand the issues around copyright also. But we were so glad that they reached out, and they always do. Every time they want now to put out a competition, they will always reach out and say, we are putting out a competition for this. How do we go about this? How do we go about this? So like Kekobo, when it comes to copyright, when we notice something like that, we'll issue an advisory on social media and say, be advised that once you enter this competition and this happens and this will happen, you need to be careful about 1, 2, 3.
Yeah.
Okay, the other thing is, no, people don't monitor the competition's IP. I mean, if you're doing if you're a startup or an entrepreneur in a certain area, you need to monitor the IP filings and trends in the market. Yeah, you can do this, as I said earlier, through patent landscape analysis, trademark or design searches. You go search the trademark database, the design database. This information will give you early warnings, about the tools, the technologies, the products that your competitor is introducing into the market. But it also allows you to respond in a strategic manner, yeah? And as I said, it can give you ideas of research and development or marketing activities. You'll get very many ideas out of it. If you ask Victor, I'm sure if you ask many SMEs and startups, they even have no idea there's a trademark database that you can search or a design database that you can search, They'll tell you, I'm a startup in this area, but they have no idea what is out there. And so it's always good to do this, to keep yourself updated in that area wherever you're working in. If right now I decide I'm going into manufacturing, I would need to keep myself updated. What is the competitor's IP in the area of manufacturing? What am I manufacturing, and what is the IP around this area at this point? So that's one of the things we found that also most people will not do. This one is related to the next one, not identifying existing IP. Most startups and SMEs fail to recognize existing valuable assets within their businesses. So if you're not aware of a valuable intellectual assets, it prevents you from coming up with a protection strategy. This is often the case with highly technical startups that dismiss the know-how as generic or ignore available trade secrets or protections as an alternative to patenting. As I said earlier, remember, the other alternative to patenting would be protecting your thing by a trade secret. And the trade secret is just that, keeping it a secret, yeah? So a startup should periodically ask, what is it that we are doing better than others? The answer is likely to point you towards an intangible asset that would be worth protecting, yeah? I have met a lot of people who even have IP that they don't know about, yeah? And usually I have told, especially companies, I usually say you need to do an IP audit within your organization. What does that mean? That means I'm auditing what IPs do I have? Because sometimes you find you can be doing one thing, but it gives you IPs across the board. So if I'm a startup or an SME, most likely I have a trademark, yeah? What is identifying my startup, my SME, my company? I most likely have a trademark. I most likely will have something that I can protect via patent. And I most likely will have something that I could protect via copyright. Maybe a software, maybe whatever. So it cuts across. But sometimes you have these things, but you don't know, even within that startup, what do I have? I always tell a lot of them, part of identifying your existing IP is auditing your IP, auditing what do I have within me, that is protectable, yeah, that can be protected by IP.
And you need an IP lawyer for that.
Yeah, if you don't know what IP is and how to, you see, if you don't even know, you don't even know maybe software and computer programs are protected under copyright, then you won't know when you're doing your IP audit, you wouldn't know you have a copyright. You're sitting on a copyright, yeah? So at least it's good to get the basic knowledge. What is IP? Then you start identifying what IPs do I have within my startup? Could this fall under a patent? Could this fall under copyright? And sometimes it's good to take advantage of what is at your disposal. As I said earlier, within Kekobo, we are able to help in terms of identifying for you what is copyright, helping you audit that would be able to help with that. And just, giving legal advice where you don't have to pay for it, that Kekobo has been doing and is able to do.
But I literally have to come to your offices.
Yeah, it would be easier to come here. I'm not going to use my transport to come to you, Victor. And my time, it would be easier to come here.
Okay.
Yeah. And we are in Nairobi, Victor. We are not in Mfangano Island.
But the challenge here is, of course, a startup within we can reach you, but someone in Mombasa.
The ones outside, yeah. Well, you can use technology. I mean, like now, I'm not with you where I am, but we are talking. You know? Yeah. So right now, at least these webinars have helped us, yeah?
Yeah, so I think our plan is to be able to do such conversations every so often, either every quarter or every month, depending with the appetite that is out there.
Yes, yeah.
But
the other thing, yeah. What did you say?
I was saying quarterly might work better.
Yeah, it might be more practical. Yeah. The other issue is lack of IP documentation. This can include not documenting or recording your ideation whiteboarding sessions. It's always a good habit to keep records of your ideas as they're flowing. As your ideas are flowing and research you're conducting, it's good to document that, because you then really don't know these ideas, what they could turn into, yeah? And Victor, I still disagree with you. You don't protect something when it has hit. You protect it when it's just there, when it has been created. You never know, it could actually hit, yeah? I have, part of my work here is approving the copyright registrations, and so I usually would open the document to see what it is and whatever, and there's times I've opened a song and I'm like, oh, wow, that's a beautiful song, yet it's not a hit. It's not a hit, it's not yet out there, probably people don't even know it, but I will listen to it and I'm like, my goodness, that is beautiful. This is definitely a nice song.
Yeah.
And in my head, I'm just telling myself, I hope this person is able to market and put this thing out there because it's really nice, yeah?
Yeah.
I have once come across a birthday song that was really brilliant, and I'm like, we need to move from happy birthday to you, na 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 na, the same. And I'm like, wow, it's just a beautiful birthday song. I'm like, this person really needs to market this thing, yeah?
Yeah.
And you can just see the issue is just there. Maybe it's not known. They have not marketed it to the point that it is known enough to be a hit.
But there lies the challenge. I mean, sometimes if you find a creative is not an entrepreneur as such.
Yes.
And for me, and this is the bigger challenge we have around IP. There's a lot of conversation of how do we have a big stock of IP that has significant commercial value, but we don't have programs that links that person who has maybe the new birthday song with someone like me who understands how to go to market.
Yes. Actually, that has been the undoing of many creatives. They're not business people.
Yeah.
If you think about music, for example, they're about the show and not the biz. Yeah. So it's showbiz business, but they know show. They don't know they don't know business. And that has been an undoing for most of them. If I give you an example of Sauti Sol, that is one group that really got it right, because they created a company that deals with business, and then the creatives remained the creatives. Sauti Sol have a general counsel, a lawyer, who's employed and by the company, and he works for the company, and they do the business part of it. But then the creatives, the guys who sing and create the songs, remained creatives. And then the company did the business for them. And that's why they're able to make a lot of money with their songs.
Is this an opportunity, maybe probably for you, for
Yeah.
you to partner with people who can be able to give capacity building or develop what we call incubation program that is able to link people who've not been able to commercialize their IP to either entrepreneurs through a platform of sorts? Do you see that as an opportunity?
Oh, that's definitely an opportunity. That's definitely an opportunity. But you know how government works? Whatever I do needs to be in line with my mandate, yeah? The mandate of Kekobo.
Yeah, so the challenge here is you have IP, you have building programs that you run. This building could be either, I don't know, enlightenment, training people on IP. It's just an extension of saying we'll do capacity building, but right now we are going to focus on supporting you, either in terms of, and there are partners that you can partner with. To build the business skills of people who hold IP.
Yes, exactly.
That's where the opportunity.
Yeah, I think there's what is that? There's an organization that's been trying to work that out. I will look for the name and share with you, yeah. And they were actually trying to do that together in conjunction with USIU, the business school. And Kekobo had been brought in, even KRA had been brought in to give some information around tax and business and all that.
For me, the way I'm looking at it is the big challenge that we have in Kenya is there's a lot of IP stock lying idle. Whether it is in universities, whether it is, different institutions, public, and yesterday, even when we were talking with Kefis, was if you go to Calro, if you go to a lot of these public institutions, they generate a lot of IP, but it doesn't see the light day of the market. So for me specifically, we can be able to support Kekobo, design a program and deliver, of course, through partnership or even for ourselves, to be able to bring people who are in your database, be able to develop a program of sorts around business management, product development, so that we IP from IP to a product, to a company, and possibly to market. So that's where that's something that I've picked as an outcome.
As an opportunity, yeah. This PowerPoint of mine is misbehaving. I've had to stop sharing and start again.
Yeah, that's fine.
Okay, so
at least you are on number 7 documentation.
Really?
No, I'm saying the last one I saw was lack of IP documentation. I think now you are going to it.
Okay, this thing is not moving.
Yeah, no,
then.
You don't even put it on slideshow. You can just have it as such.
Okay. Number 8 in innovation without rights, building a startup on like university owned technology. So most early stage startups will have to build their product on top of an existing IP platform, particularly in the context of academic innovations. Yeah. Actually, within universities, you will find there are lots of startups within universities. Yeah. A researcher could simply assume to have rights on the innovation by virtue of being the inventor. Yet, you find that if you are in a university and you're doing this for the university, then the university is the one that has the rights. However, most of the time, this will not be the case. IP rights on technology are more likely to belong to the university. Most people don't know that. And I think I've even been consulted before on an issue with a university professor who had an issue with IP with the university. And it's just that they didn't know that if I work here and I'm churning out research and development and I'm churning out innovations, they belong to the university. Also within universities, remember there are technology transfer centers. But most of the people who work within sometimes don't even realize that whatever it is they create, the technology belongs to the university. Yeah. So as a startup, even if you started up within a university, you need to know this IP belongs to who. So if I'm building on it, where will my ownership come in and all that? So, and what am I putting in? Yeah. What am I putting in? What am I not willing to put in? The entrepreneur or researcher will ensure that the startup is entitled to use the innovation, often through a license agreement with the university, yeah? Or it's just a permission, yeah? At least you have the permission or you have a license from the university to use that, yeah? I like this one, Victor, and you may disagree because you're talking about cost. There's no budget for IP protection, not using IP experts
Because they are
to
broke.
obtain IP
They are
rights.
broke. It's not that you don't have budget. A lot of them are broke. You can talk about big corporates not having budgets, but even
Yeah,
even big corporates, and even as a culture, a country, or even as you know, as a culture, we rarely put money for research and development.
yeah,
If you look at the balance sheet of a lot of even big corporates, you know, I mean, the component of research and development, and you know,
yeah,
diving into that is not there. Even as a country, if you look at the country itself, in terms of allocation,
yeah,
creating new knowledge,
yeah,
I mean, we are not there yet, and we don't see that value. So that's why for me is looking for creative ways of ensuring that small businesses as well as startups are generally broke. They don't have
yeah,
much resources. And even we did a study last, I think we launched last week, or around
yeah,
digital, or even adoption of digital tools by SMEs. You'd realize that because of the lack of resources,
yeah,
not able to take advantage of emerging technologies, etc. And looking at other cases in Brazil, you see it takes the effort of the national government with World Economic Forums and the rest to be able to give support to such. So I think we need to be creative. I'm not.
Yeah, we need to be creative with that, but it's important at least to do registrations. I always tell like the beginners, start with the easiest thing to register. For example, like copyright, it has been cheap. It's 100 bob, and it's been easy. It's online. You don't have to come here. You just upload your things and whatever. And yet, you know, there are IPs that cut across. You can register an app or a computer software for copyright, but still you may find it qualifies for a patent also. A patent may be more tedious, longer, and more expensive, but a copyright is cheaper and easier to do. So I say, do the basics first, as you hope that you'll be able to do the more expensive, more tedious one. Yeah. The other one, by the way, is the last one is not protecting in the right jurisdictions. Yeah. You see, IP laws differ from jurisdiction to jurisdiction. The IP laws in Kenya will differ from Uganda, whatever. But you see, you need to map out where is my market? Where am I targeting? Yeah, which place am I targeting? And so you would also want to protect your IP in the correct jurisdictions. Recently, I saw there's a gospel musician from Rwanda that I really like, Israel, who's called Israel. And he sings in Swahili, which is not like commonly spoken in Rwanda. Yeah, they know a bit of Swahili, but it's not like here. It's not like Tanzania. So his market has ended up being more Kenya, Tanzania, Kenya, Tanzania. That's more of his market. His song gained, I think, almost 14 million views. Yeah.
Yeah.
And so if I was that person and I was going to register my copyright, I would come register in Kenya. If that's possible, I'd go register in Tanzania, because that's a bigger market where it is. Yeah. So I think that's the other thing that people need to check and see. Even a trademark, I have to come register here. If I'm going to register, go register in Uganda if that's part of my market. You have to protect your IP within the right jurisdictions. That's the other thing that entrepreneurs need to know and typically need to get doing. I know with the promulgation of it's called the Kampala Protocol on voluntary registration of copyrights. people are able to register their copyright with the African Regional Intellectual Property Office. And particularly because there's some countries that don't have a registration mechanism within their law. Kenya we have, but other countries don't have. So you may find that, or trademark, there's a way in which if you file a trademark with that, a RIPO or with the WIPO, you can protect in several countries. Of course, it would be more expensive and all that, but then it depends. Is this on that thing and the market that you're targeting? Yeah. So there are ways of actually doing these protections. Victor, I know I've talked a lot, and I also need to. I have another training at 11, but it's not far.
Yeah, but I think that has been a fantastic revelation. I think I was taking notes as well. I think maybe you can also share the slide. I think we can also, as part of dissemination, we can be able to share that. I think in terms of an outcome, I've been able to pick that probably we need to be able to have consistent engagement so that we can have those cross learnings. Possibly, if a lot of SMEs don't have budgets, quote unquote, we can be able to find ways in which they can be able to access you, or we can be able to have sessions or webinars for you to be able to share this knowledge and be able to give support. So thank you very much. I think that I'm really, really grateful. I know we've taken a lot of time, but I think it's usually good to record, and people can always go back and make reference to this type of positions. Because I've been recording, what I'll do is either we'll upload it on our YouTube channel, then you can be able to share the link, which I'll do that in the next hour, which I'll be able to share, and possibly you can just be able to disseminate together. So asante sana. I hope continue collaboration.
Yes.
Thank you very much. If in case you know of any other, because we've reached out to ACA, the Anti-Counterfeit Authority, I think they're a bit slow in terms of response. Or any other body that
can give you a contact at ACA.
Yes. I think that would be important. I think possibly we are looking at reaching a point where we can have all the, I think, 5 IP regulator bodies together, a consolidated breakfast, so that we can see where we can be able to get synergies.
Okay. Okay.
So thank you so much, and I would want to wish you a lovely day.
Thank you.